Welcome to the deep dive. You sent us some really interesting material this time,
Yeah, chapters covering sustainable marketing, social responsibility, and ethics.
and also one on the nitty-gritty of legal issues in marketing.
Right.
So think of this as, well, your guide to seeing how these aren't separate things. They're really, interconnected for businesses today.
Yeah, absolutely. Two sides of the same coin.
Our mission here, to give you a clear, actionable understanding of how that ethical responsibility side and the legal requirements really mesh together in marketing.
Let's do it. Let's unpack this stuff.
So maybe starting with the why. Why do we even have all these regulations in marketing and business?
Well, at its heart, it's about trying to keep things fair. The legal chapter points to like three main goals:
Okay.
protecting competition, keeping consumers safe, and looking out for the public interest more broadly.
Right, like those zoning laws maybe. Keeping liquor stores away from schools, that sort of thing.
Exactly, that's a classic public protection example.
Mm.
Or think about product labeling, making sure you actually know what you're buying. That's consumer protection.
And price fixing.
That's all about protecting competition, keeping the marketplace dynamic so prices, stay reasonable for everyone. The law steps in when the free market might lead to unfair outcomes or harm, trying to balance everyone's interests.
It's interesting, though, the legal chapters seem to suggest that for things like products and ads, the main focus is really on protecting you, the consumer.
Yeah, keeping you informed, keeping you safe.
But then when it shifts to pricing or how products get distributed, it's often more about keeping the playing field level for the businesses themselves.
That is a key distinction, yeah. And remember, not everything fits neatly in those boxes. You've got intellectual property law, patents, trademarks, copyrights. That's about protecting the actual creations, the innovation.
The company's assets, basically.
Yeah, exactly. And, when companies in a supply chain have disputes, often it just comes down to breach of contract. Did someone stick to the agreement they made?
Makes sense. You agree to terms, you follow them.
Yeah.
So, okay, shifting gears a bit, the other chapter on sustainable marketing. That brings in this idea of meeting today's needs without messing things up for the future.
Precisely. That's the core of sustainable marketing. It's much more proactive, more responsibility focused than just, ticking the legal boxes.
So not just reacting to laws, but thinking ahead.
Thinking ahead, considering the broader impact, taking ownership beyond just the bare minimum the law requires. It's like following the speed limit versus choosing a fuel-efficient route. One's compliance, the other's responsibility.
Okay, so we have that baseline, the legal rules you have to follow, and then this bigger space of sustainability, ethics, being proactive. Let's dig into specifics, maybe start with intellectual property. Protecting products, that seems pretty foundational.
Absolutely. And it can get complicated fast. When a company creates something new, like how a product works or even just how it looks, patents are a big way to protect that.
Right.
And the legal chapter distinguishes between utility patents, that's the function, how it works.
Like that doghouse example, maybe.
Uh,
Better insulation because of the shape.
Yeah, functional advantage. And then design patents, which are purely about the look, the ornamental appearance, like maybe the specific cool shape of some bicycle wheels.
And the utility patents, they seem stronger, right? 20 years protection versus less for design. But the chapter said getting one is just the start.
Oh, absolutely. Getting the patent is step one. Defending it, that can cost a fortune. Hundreds of thousands, easily.
Wow.
Plus, sometimes the patent office grants patents that kind of overlap, so then you end up in court battles figuring out who actually owns what.
Messy.
And even if you win, courts try to balance things. They want to reward innovation, sure, but also keep competition alive, so they might let competitors make something slightly different design around the patent, they call it.
So a patent helps, but it's not like an impenetrable shield.
Not at all. A significant step, but challenges are always possible.
Okay, what about copyrights? That's your creative stuff, right?
Yeah.
Music, books.
Yeah, literary, musical, artistic works, even software code. Getting a copyright is easier, actually. You create the work, put the notice on it, you've got basic protection.
How long does that last?
For individuals, it's usually their lifetime plus 70 years. For companies, it can be like 95 years from publication or 120 from creation, whichever's shorter.
But enforcing it is still tough, like patents.
Pretty much. Finding people who are infringing and then actually suing them, that takes effort and resources.
Right. Okay, so protections exist, but they've got hurdles. Let's talk about something every business thinks about. The brand name.
Crucial. Legally, the whole point of a brand name is to tell you who made the product or service. It has to be distinct, so people don't get confused and think your stuff is from someone else.
Can't just use your own name if it's confusingly similar.
Nope. Even if it's your actual name, like the McDonald's example in the text shows, if it causes confusion with an existing trademark, even in a slightly different field, you could have problems. The law wants to prevent consumers getting mixed up about where things come from.
Makes total sense. So how do businesses lock down these names? Are there different levels?
Yeah, there are layers. Lots of small businesses start with just, well, using an unregistered name. Then you can register a doing business as, or DBA name at the county level. That's mostly for transparency, telling people who's behind the business. Doesn't offer much protection, though.
Okay.
Stepping up, you can register with the state. That gives you rights within that state, even where you're not operating yet.
And the strongest.
Federal registration.
Yeah.
With the U.S. Patent and Trademark Office. That gives you nationwide rights renewable every 10 years. So it's like local, state, then federal, increasing levels of protection.
But even that federal registration, it's not automatic immunity from lawsuits, is it?
Definitely not. You might still end up defending it in court. And several things matter there. First, prior use is huge.
Meaning?
If you can prove you were using a name before someone else registered it, you might still have rights in your local area.
Oh.
Then there's the use it or lose it rule. Stop using your trademark and you could lose the rights.
Right.
And the big danger is your name becoming generic, like Aspirin or Escalator. Those used to be brand names. If everyone starts using your brand name just to mean the product type, you lose trademark protection.
Wow, so companies have to actively fight that.
They do. It's a constant battle for some famous brands.
So when courts decide if one name infringes on another, what's the main test?
It boils down to likelihood of confusion. Would a decent number of consumers probably think the second company's product is actually from the first company or somehow connected?
How many consumers is decent?
Well, the chapter mentions some courts use around a 20% confusion level as a kind of benchmark, but it's not exact. Think about the Bluebonnet margarine example. If someone launched Bluebonnet milk, even though it's milk, not margarine, is there a risk of confusion? Probably.
So names don't have to be identical, products don't have to be identical.
Exactly. Courts look at how related the products are, who the typical buyer is, are they sophisticated or easily confused, did the second company intend to cause confusion, and how strong is the original trademark.
Strong. What makes a name strong?
Arbitrary names like Kodak or Exxon get the strongest protection because they're made up. Descriptive names like Citibank or Light Beer are weaker. They might need to show secondary meaning.
Meaning consumers connect that descriptive name specifically with their brand.
Precisely. They have to prove people hear light beer and think Miller, not just any light beer.
So the lesson for anyone listening is, do your homework, search for existing names before you launch.
Absolutely. Get a professional search done. And know that descriptive names are harder to protect.
What about slogans, like got milk or something?
Slogans usually get limited protection unless they're really distinctive or gain that secondary meaning where people instantly link the slogan to the brand. Otherwise, it's tough to stop others using similar phrases. The florist using, "For all you do, this bud's for you." Probably okay, because the context is so different from Budweiser beer, confusion is unlikely.
And the overall look, the packaging, trade dress, they called it.
Right, the look and feel, like the Nestle yellow and brown bag or the Kendall Jackson leaf on the wine bottle, that can be protected as a trademark, but courts are careful not to give overly broad protection, otherwise it becomes like a permanent design patent.
So you can aim for a similar vibe as a competitor, maybe.
Generally, yeah, as long as your brand name and key elements are different enough that people won't get confused, it's a balancing act.
Okay, that's a lot on intellectual property.
Yeah.
Let's shift to the actual product itself, safety and information. That seems critical too.
Absolutely fundamental. Product safety rules are all over the place, inspections, performance standards, banning certain ingredients. Different government agencies handle enforcement depending on the product.
And messing this up is bad news.
Huge news. Plant shutdowns, product recalls, massive lawsuits. Compliance isn't optional. It's essential for survival, really, ethically and practically.
And labeling fits in here too, making sure people know what's in the product.
Exactly. Rules dictate what info must be on the label, ingredients, nutrition facts, warnings. Sometimes the rules even define what a product needs to be to use a certain name. Like you can't just call anything ice cream.
Need a certain amount of butterfat, right?
Right. It's all about transparency, giving you the info to make choices. And again, non-compliance carries big risks for the business.
Now, what if a company promises something about the product, like a guarantee? The chapter mentioned warranties.
Yeah. If a company makes a specific promise about quality or performance, that's an express warranty. If it's a really broad guarantee, it has to be labeled full warranty and spell out your rights.
And if it's less comprehensive?
Then it's a limited warranty. But here's the thing. Even with no written warranty, U.S. law usually implies certain warranties,
Right, I'm at.
unless they're specifically denied. There's the warranty of ownership, the seller actually owns it. Warranty of merchantability, the product is basically fit for its normal purpose. And warranty of fitness for a particular purpose, if the seller recommends it for a specific use you asked about, it should work for that.
Can sellers get out of those implied ones?
They can get out of merchantability and fitness by clearly stating, as is no warranty. You see that on used cars sometimes. But they can never disclaim the warranty of ownership.
Okay. And this all leads into product liability, right? When things go wrong and someone gets hurt.
Directly. And the big concept here, especially since the 60s in the U.S., is strict liability.
Strict meaning?
Meaning a company can be held responsible for harm from a defective product, even if they weren't negligent, even if they didn't technically breach a warranty. The key is, was there a defect, and did it cause injury when the product was being used reasonably?
Wow, so intent doesn't matter as much.
Not really. Under strict liability, it puts a huge responsibility on businesses to ensure safety because they can be liable regardless of fault in the traditional sense.
Yeah.
Good design, good manufacturing, good warnings become absolutely crucial.
So if a product has a flaw, someone gets hurt using it normally, the company's potentially on the hook.
That's the essence of it. And the chapter outlines 3 main types of defects. Design defects, the whole design is flawed.
Like a car prone to rolling over.
Could be. Then manufacturing defects, something went wrong during production. Like that awful example of glass in baby food. And failure to warn defects, not giving adequate warnings about risks that aren't obvious.
And who can get sued? Just the final manufacturer?
Nope. Anyone in the chain, the company that made a faulty component, the designer, the wholesaler, the retailer, potentially all of them. It's a wide net.
That's huge. Are there ways companies can defend themselves?
Yes, there are defenses, but none are guaranteed wins. Assumption of risk, the person knew the risk and did it anyway.
Like extreme sports?
Maybe. Obviousness of risk, the danger was so clear anyone should have seen it. Misuse of the product, using it in a totally unforeseeable way, like the lawnmower hedge trimmer example.
Right.
Preemption, arguing that federal safety standards were met, so state liability claims shouldn't apply. And the state-of-the-art defense, arguing the product was as safe as possible given the technology at the time it was made.
Sounds like a legal minefield. And the chapter mentioned costs are rising, especially with class action lawsuits.
Definitely. Class actions, where lots of people join one lawsuit, can lead to enormous payouts. And the way lawyers often get paid in the U.S. contingency fees means there's an incentive to bring these big cases. Businesses are definitely feeling it.
That Kawasaki Ninja ad example, the fast driving, the tiny disclaimer, that really shows the tension, doesn't it?
It really does. Marketing wants excitement, but liability is always lurking. How effective is that closed track warning, really, when the whole ad screams speed? It's about foreseeability of harm.
Okay, let's switch to the money side and getting products out there, pricing and distribution. Legal lines here too, I assume?
Oh, for sure. Pricing first. Horizontal price fixing, that's competitors getting together to set prices, is a huge no-no. Absolutely illegal.
Big penalties?
Massive. Civil damages can be tripled, and there can even be criminal charges. The hard part is sometimes telling collusion apart from just, everyone reacting to the same market forces. Rule 1, don't talk price with competitors. Period.
Okay, clear enough. What if a manufacturer tells a retailer what price to charge?
That's vertical price fixing or resale price maintenance. Manufacturers can suggest prices, sure, but they generally can't force retailers to stick to them. That could squash competition, just like retailers fixing prices themselves.
But they often suggest high prices, right?
Yeah, and that often acts like a ceiling. The real fights happen when manufacturers try to stop retailers from discounting. That looks a lot like illegal price fixing and can land them in court. It's a tricky balance between brand image and retailer freedom.
What about selling below cost? Is that allowed?
Usually, yes. Selling cheap to clear inventory, for a promotion, matching a competitor that's generally fine, it becomes illegal if it's predatory pricing.
Meaning?
Meaning you're selling below cost specifically to kill off competitors so you can jack up prices later. But proving that intent is really, really hard.
And dumping.
That's selling imported goods here cheaper than they cost to make back home. Also illegal, but again, proof can be tough.
Price discrimination. Charge you different folks different prices.
Okay, here's the distinction. Under the Robinson-Patman Act, it's generally illegal to charge different prices to different resellers, wholesalers, retailers, unless you have a good reason.
Like what?
Like the goods are actually different quality, or it genuinely costs you less to serve one buyer, maybe they buy huge volumes, or you're just matching a competitor's price for that specific buyer.
But you can charge different prices to regular consumers.
Generally, yes. Charging you one price and me another for the same thing is usually fine. Robinson-Patman was really aimed at protecting small stores from giant chains getting secret sweetheart deals from suppliers.
So discounts for bulk orders are okay, as long as everyone has the same chance to get them.
Pretty much. If the terms are offered equally based on things like order size or delivery costs, that's usually permissible.
Okay, that covers pricing pretty well. Now, distribution, getting the product to the customer. What are the legal traps there?
Contracts are king here. Lots of relationships, especially exclusive ones like giving one distributor a whole territory, or them agreeing only to sell your brand, involve detailed written contracts.
And if someone breaks the contract?
Lawsuit time. Breach of contract. But even without a written contract, courts might look at how things have always been done between the parties, or standard industry practice. That's the principle of reliance.
Exclusive distribution, one seller per area. Doesn't that limit competition?
It used to be viewed more suspiciously. There was a time it was almost automatically considered illegal, but now the courts use a rule of reason. They ask, does the benefit to competition between brands, like Coke versus Pepsi, outweigh the harm to competition among dealers of the same brand, like two Coke distributors? If it helps a smaller company compete better against giants, it's more likely to be okay.
So it depends on the situation.
Exactly. And often these disputes end up being argued as contract issues anyway, not pure antitrust.
What about exclusive dealing, where a store agrees to only carry one brand?
That's usually allowed. The idea is, even if that one store only sells brand X, you can still go down the street and buy brand Y. So competition isn't usually harmed much.
Are there exceptions?
Rarely. Maybe if a huge company locked up all the good distributors with exclusive deals, effectively blocking a new competitor from even getting their product onto shelves. The Ben & Jerry's versus Haagen-Dazs thing touched on that.
Tying contracts by product A to get product B. Those sound iffy.
They can be. Especially if the first product, the tying product, gives the seller a lot of market power, like the old Xerox example. Had to buy their service contract if you bought their copier. Or maybe a franchise like KFC requiring franchisees buy supplies only from them.
Seems like it could be used unfairly.
It can be seen as leveraging power in one market to force sales in another. But sometimes it's hard to tell what's an illegal tie versus just selling things as a bundle.
Can a manufacturer just refuse to sell to a distributor? For no reason.
Generally, yes. Manufacturers and wholesalers usually have the right to choose who they deal with, unlike retailers who often have laws about serving everyone.
But what if they stop selling to a distributor they've worked with for years, terminating them?
That's much more likely to lead to a lawsuit, even if the basic right to refuse exists. It hits the distributor hard. Having a clear written contract outlining termination rules is the safest bet.
And the risk of a lawsuit depends on how important that product line was to the distributor.
Exactly. Losing a minor product line might be annoying. Losing your main supplier like Amana or Cooper, as mentioned in the source, that could trigger a major fight.
Right. Okay, we've hit product, price, place. Let's tackle the last piece, promotion. Selling, advertising, legal and ethical issues there too.
Definitely. With personal selling, a big one is that your company can be held responsible for what your salespeople say.
If they make misleading claims.
Yep. That can create an express warranty you have to honor, or even expose you to liability if someone relies on the claim and gets hurt. Training and supervising salespeople is key.
And no bribes, obviously.
Absolutely not. Bribes and kickbacks are illegal, both here and internationally under the Foreign Corrupt Practices Act.
What about just really aggressive sales tactics? High pressure.
Generally legal, but it can definitely raise ethical flags, and some states give consumers a cooling-off period to cancel big purchases made under pressure at home.
Telemarketing. Any rules there?
It's getting more regulated, but still relatively few broad restrictions compared to other areas. Some laws target specific, annoying practices, like those automated dialers that won't hang up.
Sweepstakes and contests.
Those fall under gambling laws, mostly at the state level.
Yeah.
You need clear rules. Disclosures can't usually require a purchase to enter.
Okay, now the big one. Advertising.
Huge area. The main rule.
Yeah.
No deceptive advertising. An ad is deceptive if it's likely to mislead a reasonable person.
Not just outright lies, but misleading.
Right. It's different from puffery, though.
Puffery.
Harmless exaggeration that no one takes literally, like that old Desenex ad implying your feet might burst into flames. Nobody believes that. That's puffery.
Who enforces the rules against deceptive ads?
Primarily the Federal Trade Commission, the FTC. They can stop ads, even force companies to run corrective ads. Remember the Listerine case? They had to advertise that Listerine doesn't prevent colds after claiming it did. State attorneys general also go after deceptive practices. And there's industry self-regulation through the National Advertising Review Board. Bottom line, be truthful and have proof for your claims before you run the ad.
Retailers' advertising prices have extra rules.
Yes, FTC guidelines. Need enough stock or offer rain checks. Be clear if quantities are limited. Be honest about comparison prices. Is it the manufacturer's suggestion, a competitor's price, your own regular price?
Why all those rules?
To prevent bait and switch, luring you in with a cheap price on something they barely have than trying to sell you something pricier.
The chapter also mentioned unfair and undesirable advertising. What's that?
Unfair is broader than just deceptive. It might involve exploiting vulnerable groups. There are special rules for drug ads. Prescription drugs need FDA okay for ads to the public, and ads aimed at kids need clear separation from shows, realistic toy depictions.
And undesirable.
That's about products society has concerns about. Cigarettes can't be advertised on TV, need warnings in print. Alcohol ads have restrictions too, especially hard liquor on TV historically. Even media outlets themselves might refuse certain ads, like for condoms or really nasty comparative ads.
It's a real balancing act, isn't it? Commercial speech versus public health or protecting kids.
Absolutely. And it varies globally, too. The sources highlighted some key differences.
Right. How does regulation in the U.S. compare to, say, Europe or Japan?
Similar goals overall, but different execution. Big one. Jury trials for business disputes are common here. Not so much elsewhere judges usually decide.
Makes outcomes less predictable here, more emotional.
Can be. Also, lawyers working on contingency fees getting paid only if they win encourages more lawsuits here. We just have more lawyers per capita, too.
And our system is complicated federal and state laws.
Very fragmented. Plus, we have common law court decisions set precedents. Europe mostly uses code law. Comprehensive written statutes are the main source.
How does that affect marketing specifically?
Well, exclusive distribution deals might be easier to enforce over there. Comparative advertising naming competitors is okay here, but often restricted elsewhere. Product liability tends to be less severe, lower payouts in Europe and Japan. And of course, specific rules on product safety, ingredients, labels just differ country by country.
What about less developed countries? How do they compare to industrialized ones?
Some general trends. LDCs might actually encourage monopolies sometimes, maybe to build up national companies. More government intervention often. Consumer protection is usually weaker.
And protecting ideas, patents, trademarks.
Often weaker protection in LDCs too. Counterfeiting can be a bigger risk. Interestingly though, even with weak legal protection, brand loyalty can still be super strong in those markets.
So a strong brand reputation matters everywhere, even without strong laws.
Yeah.
Okay, last big area from the legal chapter. How does this regulation stuff actually happen? Who makes the rules, how, and who enforces them?
It's a mix. Legislatures pass laws. Regulatory agencies like the FTC make detailed rules. Courts interpret laws and make precedent-setting decisions. Sometimes even public votes, though that's less common for business stuff. And it happens at local, state, and federal levels.
Like the soft drink bottler example. Court decisions shaped the rules on territories, then Congress stepped in.
Exactly. Shows the interplay.
And how do these rules get started?
Often, it's interested parties frequently businesses themselves pushing for rules that they think will help them. They lobby legislatures, petition agencies, file lawsuits, maybe back ballot initiatives.
So businesses try to influence the rules.
All the time. And they might choose where to push based on where they think they'll get the best result. Legislatures respond to political pressure, courts to legal arguments, agencies to industry influence sometimes.
And the stated reason for a rule might not be the real reason.
Sometimes. The Texas horse racing example suggests that. Stated goal. Jobs and development. Underlying driver might have been competition between different gambling interests.
And finally, enforcement. A law is written, but does it always get enforced?
Not automatically. Enforcement often happens because someone, an individual, another company, files a private lawsuit. Government agencies enforce too, but private lawsuits are very common.
So it relies on the courts.
It relies on the judicial system, yeah. Judge or jury has to hear the case. And just because the law says X doesn't mean the outcome is guaranteed.
Why not?
Well, the super specs optical chain story in the chapter was a great illustration. Skilled lawyers, believable witnesses, maybe even the judges or jury's biases can sway things. The super specs case looked like it involved antitrust issues, exclusive territories tying up poorly. But the court ended up deciding it based on contract law details.
So it's complicated, not just black and white.
Far from it. A law only has teeth if someone takes action to enforce it, and even then, the outcome in court can be uncertain.
Okay, let's try and wrap this up. We've covered a huge amount of ground digging into the legal and ethical side of marketing based on the chapters you sent over.
Yeah, and I think the big takeaway is how linked these things are. Legal compliance is just the floor, the minimum.
Right.
But that sustainable marketing chapter really pushes the idea that going beyond that, truly embracing ethics, thinking about social responsibility, that's what builds strong brands, builds customer trust, and leads to success in the long run.
So hopefully this deep dive has given everyone listening a better handle on these really complex, interconnected areas.
We hope so.
And maybe here's a final thought to chew on. We know consumer attitudes change, laws evolve. So how can businesses get ahead of the curve? How can they weave ethical thinking and social responsibility right into their core strategy, not just as a legal defense, but as a way to genuinely create value and build that lasting trust?
That's the key question, isn't it?
Definitely something to think about.
Yeah.
Maybe reflect on which parts of our discussion today really stood out for you and how they might apply in your world. Thanks for joining us on the Deep Dive.